Hi, and welcome to the Edmonton Community Legal Centre's presentation of wills and estates. The information presented during this session may have limited application to your particular situation. I, as a lawyer, can provide legal information that may give you a greater understanding of how the law might apply to your own situation. When we talk about estate planning tools, we're often referring to three different legal tools. We have a will, there's the enduring power of attorney, and a personal directive. The will's overview will cover a number of areas. We'll cover what is a will, the advantages of making a will, the Wills and Succession Act, the legislation in the province of Alberta, the requirements of a valid will, who can make a will, the effect of marriage and divorce, the limitations on testamentary freedom, what's involved with proving a will, the court powers, the roles of the executor, and what happens if you don't have a will. What is a will? A will lets you make decisions that will be carried out after your death. So the document really doesn't come alive until you pass away. It's a legal document containing a person's wishes concerning how your estate will be distributed and who will be responsible for the distribution. An estate is pretty much everything that you own. It's land, your assets, bank accounts in your name alone, and insurance payable to your estate. Property not forming part of your estate includes joint property owned by spouses and life insurance, RRSPs, and pensions where the estate is not the named beneficiary. The legislation in the province of Alberta is called the Wills and Succession Act. It became effective in February of 2012. It repealed and replaced the Wills Act, the Survivorship Act, the Intestate and Succession Act, the Dependents Relief Act, and Section 47 of the Trustee Act. All provinces have their own legislation. What are the requirements of a valid will? Section 15 of the Wills and Succession Act refers to a formal will. A formal will must be in writing, must be signed by the testator, and the testator refers to you. The testator makes or acknowledges their signature in the presence of two witnesses present at the same time. Each of the witnesses signs the will in the presence of the testator, which would be yourself. A witness should not be a beneficiary or his or her spouse. Section 16 of the Wills and Succession Act provides for a holograph will. A holograph will is valid in Alberta. A holograph will must be wholly in your own handwriting and signed by you, the testator. Who can make a will? Section 13 of the Act provides that you must be 18 years of age and have mental capacity, and under 18 if certain conditions are met. There are many advantages of making a will. You exercise choice over your executor. The executor is the individual who will carry out your wishes when you've passed away. You exercise choice over your beneficiaries. You can choose charities, dependents. You can create trusts for minor children. You can create delayed gifts for them. If you don't set anything out, your child will receive your estate at the age of 18. With a trust, you can decide whether you wish to delay the gift at various ages, for example, 21, 25, 30. You can choose a trustee for the trust. You can name a guardian for minor children, and there's potentially less conflict amongst family. If you go and see a lawyer, the lawyer can provide you with tax and legal implications as well. There are limitations on testamentary freedom, family maintenance and support. Family members can apply for support from the deceased estate. Family members include your spouse, minor children, dependent adult children, that's an adult child under the age of 22 who is a full-time student, and a grandchild who depends on a deceased grandparent or great-grandparent. Let's talk about the executor. Again, the executor is the individual who will look after carrying out your wishes after you've passed away. They'll do things like locate your assets, pay funeral costs, look after your debts and taxes. They'll distribute remaining money and property according to your will. They'll be accountable to the beneficiaries, and for more complicated estates, they may need professional advisors, for example, lawyers and accountants. One of the first responsibilities of an executor is to locate assets. On that point, it's important to consider digital assets and everything that we do online. It can become very challenging for an executor if they don't have the information that they need to ascertain assets. You can choose any adult that you wish, but they're best suited if they're trustworthy, reliable, and competent. They should have basic knowledge of business, and most often they're a family member, a beneficiary, or trusted friend. They can also be a trust company. The Estate Administration Act is the piece of legislation in Alberta which provides the roadmap for executors in regards to their duties and responsibilities. The Estate Administration Act provides the personal representative, which can be either an executor or administrator, with a roadmap in carrying out their duties and core tasks. Their core tasks may include, but is not limited to, the activities or schedule that is part of the Act. A simple, straightforward estate can often take a year to administer. Marriage or an adult interdependent agreement no longer revokes a will. Divorce revokes a gift and also voids appointments to the ex-spouse. For example, we have William and Kate. They're married. William leaves his convertible to Kate and appoints her as executor. They divorce after February 1st, 2012. William dies. Kate does not get the convertible and is not the executor. Proving a will is also known as probate. After death, a will is submitted to the surrogate court for probate. It's a process whereby the court verifies that the will is valid and confirms the appointment of the personal representative. A personal representative will need probate before dealing with property. For more complex estates, the personal representative may need professional advisors, for example, lawyers and accountants. There's various court powers. The courts may admit outside evidence to establish a testator's intention. A court may also validate improper wills and alterations. What happens without a will? An intestacy is defined in the Act as an estate or part of an estate that is not disposed of by a will. Someone with an interest in the estate must make an application that appoints him or her as the administrator. The administrator has the same duties and powers as the executor. What happens to the estate on an intestacy? Part 3 of the Act provides all of the information in regards to an intestacy. Section 60 of the Act provides that if you leave a surviving spouse or an adult interdependent partner and no descendants, all your estate goes to your spouse or adult interdependent partner. Section 61 of the Act provides if you leave a surviving spouse or an adult interdependent partner and only descendants from that relationship, everything goes to your spouse or adult interdependent partner. Another example where we have a spouse plus children from another relationship. The spouse or adult interdependent partner gets the preferential share, which is the greater of the prescribed amount, which is set out in the regulation as $150,000 or 50% of the net value of the estate. The rest is divided equally among the surviving children and deceased children who left surviving descendants. Section 62 of the Act covers the situation where you have a spouse and an adult interdependent partner at the same time. For example, we have William and Kate. They're married with 2 children. William leaves Kate to live with Camilla and has a child within a year. William dies intestate. Kate and Camilla divide the preferential share. The residue, each child takes a third. Section 63 of the Act covers separated spouses. We have William and Kate who are separated for more than 2 years or have a court order settling their affairs. William dies intestate. Kate is disinherited. The next example covers Section 63, separated spouses with children. William and Kate are separated for more than 2 years or have a court order settling their affairs with 2 children. William dies intestate. Kate is disinherited. The residue, each child takes a half. If there's no family or relatives as set out in the Act, then the Unclaimed Personal Property and the Vested Property Act comes into play. If a person dies without a will, After 2 years from the grant of administration, the administrator must give the provincial government any portion of the estate not claimed by a valid heir. The provincial government must keep this property equivalent value for 10 years. If no one comes forward to claim it within 10 years, then the property belongs to the government. When we talk about planning for incapacity, we often talk about two different legal instruments. One is an enduring power of attorney and the other is a personal directive. The Powers of Attorney Act allows for a power of attorney. It's a document where you, the donor, authorize someone, the attorney, to deal with property on your behalf. One of the difficulties with the standard power of attorney is that it automatically ceases to have effect if the donor becomes incapacitated. The legislation allows an attorney to continue to act, notwithstanding future mental incapacity. This document is called an enduring power of attorney, or an EPA. An enduring power of attorney must be in writing, dated, signed before a witness, and a statement that either the power of attorney is to continue despite any mental incapacity or infirmity of the donor that occurs after the execution of the power of attorney, or the power of attorney is to take effect only on the mental incapacity or infirmity of the donor. So some key points are that the donor must have mental capacity. The authority of this instrument terminates on the death of the donor or attorney, if the trustee is appointed, or if revoked by the donor who has capacity. So what happens if you don't have an enduring power of attorney and something happens? Well, under that situation, someone would have to be appointed as your trustee under the Adult Guardianship and Trusteeship Act, another piece of legislation. It's a court order, so it would take time, it's more expensive, and it's not a private affair. A court decides who will be the trustee. Next, we'll turn to the Personal Directives Act. The Personal Directives Act provides for a personal directive, which is a legal document that you write in case something happens and you cannot make your own personal decisions in the future. They are non-financial decisions, for example, healthcare, where you live, etc. The donor appoints an agent. It must be in writing, dated, and signed before a witness. Again, what happens if you don't have one of these documents? A guardian would have to be appointed under the Adult Guardianship and Trusteeship Act. A good place to go to find all legislation is the CanLII website.